Don't do the crime if you can't do the time. It's a cultural shorthand for fairness, for the idea that justice is earned or forfeited by personal conduct. But at the heart of that phrase is a deeper assumption, that there will be a process, a charge, a hearing, a verdict, a clear line between wrongdoing and consequence, that if you follow the law, avoid trouble, and act in good faith, the system will treat you fairly in return. For international students in the United States right now, that assumption no longer holds. Over the past several weeks, hundreds of students, many enrolled at flagship public institutions like the University of Illinois, have had their legal status revoked with no charges, no hearing, and no explanation. In some cases, students were flagged for speeding tickets. Others were accused of campus misconduct that never made it to court. Some were never informed of what, if anything, they were accused of at all. And yet, their SEVIS records were terminated, their legal presence erased, and their ability to contest the decision taken from them entirely. The mechanism driving these removals is obscure but devastatingly effective. Through SEVP and ICE, the federal government has begun terminating SEVIS records using the vague justification of a criminal record check. This doesn't require a conviction, or even a charge. What's worse, it's not followed by any opportunity for redress. Normally, a student in this situation would be able to apply for reinstatement using Form 1539, supported by a reinstatement I-20 issued by their university. That form doesn't say the student is innocent. It simply allows them to ask for legal review by US Citizenship and Immigration Services. But now, schools are refusing to issue that document, not because the law prohibits it, but because they're being told, formally or informally, not to. SEVP has quietly pressured universities to shut the door, and too many have complied. This is a crisis, not just for international students, but for the integrity of due process itself. What we are witnessing is the use of administrative mechanisms to deny individuals access to legal remedy. A student's legal status is revoked, not by proving wrongdoing, but by citing unverifiable or undisclosed allegations. Then, the very institutions that could enable a review are silenced or threatened into non-participation. This is not just unfair, it is structurally unsound, a process where accusation equals outcome, and compliance by silence becomes the policy of the day. And the danger doesn't stop at international students. What is being normalized here, the use of bureaucratic systems to preempt due process, the silencing of institutions through informal threat, and the refusal to even allow individuals to enter legal proceedings, can and will be extended. Once a system is created in which access to legal defense can be denied by withholding a document or flipping a database flag, that system can be applied to anyone. A flagged background check becomes the functional equivalent of a judgment. A denied form becomes a denial of rights. This is not theoretical. We've seen echoes of it in algorithmic decision-making in housing, healthcare, and benefits. But higher education is now being used as a frontline, not only in enforcement, but in normalization. Universities, then, are more than just bystanders. They are being positioned as gatekeepers, not of education, but of access to justice. And that role is not voluntary. It is imposed, often coercively, by federal agencies leveraging the threat of SEVP decertification. But the consequences are real. Each UN-issued reinstatement I-20 isn't a neutral act. It is the final link in a process that denies a student their legal footing. And if universities accept that role without protest, they are not simply failing their students. They are helping redefine due process as something that can be denied by silence. If institutions of higher education still see themselves as defenders of critical thought, open dialogue, and legal order, then this is the moment to act. Speak publicly, challenge the pressure, issue the forms, force the federal government to adjudicate these cases openly rather than bury them in administrative opacity. Because what's at stake isn't just the future of international students, it's the future of legal process itself. If we accept that silence can substitute for procedure, we may soon find that silence is all that remains.